Counseling. We'll break it down into key concepts, important details, and examples to illustrate their roles. What are professional organizations? Professional organizations are groups that bring together individuals in the same profession to support each other, set standards, provide resources, and promote the interests of the profession. In counseling, these organizations play a key role in improving the quality of care and supporting the development of counselors. Key organizations: 1. National Board for Certified Counselors. Purpose. The NBCC is a certification organization that provides credentials for professional counselors. It focuses on ensuring that counselors are qualified and competent to provide quality services. Core credentials. The NBCC offers several certifications, the most recognized being the National Certified Counselor. This credential indicates that a counselor has met specific educational and experience requirements and passed a national examination. 2. Important details. Certification process. To become certified through the NBCC, counselors must have a master's degree in counseling, complete supervised experience, and pass the National Counselor Examination. This process makes sure that certified counselors have validated skills in the field. Continuing education. The NBCC requires certified counselors to complete continuing education credits to maintain their certification. This encourages counselors to stay current with best practices and new developments in the field. 3. Example. A counselor wants to enhance their professional standing and credibility. By obtaining the NCC through the NBCC, they demonstrate their commitment to high standards in their practice. This certification can make them more attractive to potential employers and clients. 4. Council for Accreditation of Counseling and Related Educational Programs. Purpose. CACREP is an accrediting body that evaluates and accredits counseling graduate programs. This ensures that these programs meet specific quality standards in preparing future counselors. Accredited programs. When a counseling degree program is accredited by CACREP, it indicates that the program has undergone a thorough review and meets quality standards in education, training, and curriculum. 5. Important details. Quality assurance. CACREP's role is to establish and maintain high standards for counseling education. This helps ensure that graduates are prepared to enter the profession with the necessary knowledge and skills. Alignment with licensure. Many states recognize CACREP-accredited programs when establishing licensure requirements. Graduates from these programs may find it easier to meet state requirements for licensure. 6. Example. A student is considering a counseling program at a university. They discover that the program is accredited by CACREP. This accreditation assures them that the program will provide a quality education that meets industry standards and prepares them for successful careers in counseling. Summary of roles. Conclusion. Professional organizations like the NBCC and CACREP play crucial roles in the counseling profession. The NBCC helps establish certification standards for individual counselors, while CACREP ensures that counseling programs provide quality education for future professionals. Understanding the roles and contributions of these organizations is essential for your success in the counseling field and will help you as you prepare for the CPC exam. Specific ethical issues and scenarios. Confidentiality and its exceptions. Tarasoff warnings: serious and foreseeable harm, contagious, life-threatening, diseases legal versus ethical agreements, confidentiality for deceased clients, exceptions. Danger to self, others, court order, supervision, clerical assistance, legal clinical consultation, malpractice suits, minors, elder abuse, insurance requests, privilege communication, varying state laws on privilege communication, qualified, privileged. Communication, child abuse, neglect, reporting threats of harm, minimal disclosure. Let's explore the topic of Tarasoff warnings and related concepts, including duty to warn, protect, confidentiality exceptions, and privilege communication. This is an important topic in counseling and ethics, especially as you prepare for the CPC exam. We will break down key concepts, important details, and provide examples to make everything easy to understand. 1. Tarasoff warnings. Tarasoff warnings refer to the legal obligation of counselors to inform potential victims if a client poses a serious and foreseeable threat to their safety. This stems from a landmark case involving Tatiana Tarasoff, who was killed by a man after he confided to his therapist that he intended to harm her. The therapist did not warn her or law enforcement, which led to the court ruling that mental health professionals have a duty to warn potential victims. Key points. Duty to warn. If a counselor determines that a client poses a credible threat of serious harm to someone, they must take action to protect that person. This may include warning the intended victim or contacting law enforcement. Serious and foreseeable harm. The threat must be real and likely to happen. For example, if a client explicitly states they plan to harm someone, the counselor has a duty to act on that information. 2. Contagious life-threatening diseases. Counselors may have a legal and ethical obligation to inform appropriate authorities or individuals if a client has a contagious life-threatening disease. This includes diseases like HIV/AIDS or tuberculosis, where the health of others can be at risk. Example: if a counselor learns that a client is diagnosed with a life-threatening disease that could be transmitted to others and the client is not taking precautions, the counselor may need to disclose this information to prevent harm. 3. Legal versus ethical agreements. Legal agreements, mandated by law, and can involve court orders or legal obligations to report certain actions. Ethical agreements, guidelines set by professional organizations that dictate how counselors should behave ethically, even if not required by law. 4. Confidentiality for deceased clients. Counselors generally maintain confidentiality even after a client has passed away. However, this can become complicated in certain situations, such as legal claims or when the deceased estate is involved. 5. Exceptions to confidentiality. There are important exceptions where confidentiality may not apply. 1. Danger to self-others. If a client is at risk of harming themselves or others, the counselor may need to break confidentiality to protect the client or others. 2. Court orders. If a court orders a counselor to disclose information, they must comply, even if it violates typical confidentiality agreements. 3. Supervision. When counselors discuss cases with their supervisors for guidance, they may share sensitive information to improve their practice. 4. Clerical assistance. Personal information may be shared with administrative staff for scheduling or billing, provided it's kept confidential. 5. Legal clinical consultation. Counselors may share information with legal or clinical consultants to address cases or improve practice. 6. Malpractice suits. If a client sues for malpractice, the counselor may have to disclose some confidential information. 7. Minors. If a minor is involved, legal guardians may have the right to access certain information. 8. Elder abuse. Counselors are mandated reporters and must report suspected abuse of elderly clients. 9. Insurance requests. When a client files an insurance claim, information about the treatment may be shared with the insurer. 6. Privileged communication. Privileged communication. This is the legal concept that protects certain communications between a client and a counselor from being disclosed without the client's consent. The client holds the privilege, meaning they have the right to control who hears their confidential information. Example: if a counselor is called to testify in court, they generally cannot share what the client said unless the client agrees or it falls under one of the exceptions. 7. Varying state laws on privileged communication. Different states have different laws regarding privileged communication. Some states may have stricter rules about what can be disclosed than others. 8. Qualified privileged communication. In some situations, privileged communication may be limited or qualified. For example, if a therapist believes a client poses a serious threat of harm, they might need to disclose certain information, even if typically it would be considered privileged. 9. Child abuse neglect reporting. Counselors are mandated reporters, meaning they are legally required to report any suspected child abuse or neglect to the relevant authorities. This duty to report overrides confidentiality agreements, as the child's safety is the priority. 10. Threats of harm. If a client expresses thoughts of suicide, homicide, or property damage, counselors must take these threats seriously and may need to break confidentiality to protect the client or others from harm. 11. Minimal disclosure. When breaking confidentiality, counselors should disclose the least amount of information necessary. This means they should only share what is required to protect the individual or comply legally, rather than disclosing all details about the client's case. Conclusion: understanding Tarasoff warnings and the exceptions to confidentiality is crucial for counselors. These concepts help ensure they protect their clients and others from potential harm while navigating the complexities of ethical and legal obligations in their practice. Familiarity with these principles is essential as you prepare for the CPC exam and work towards your career in counseling. Client relationships and boundaries. Dual relationships, multiple relationships, non-counseling roles, prohibited relationships, timeframes for post-termination relationships, 5 years ACA, 2 years MBCC, self-referral, virtual relationships, bartering, accepting gift from clients, sexual harassment, sexual intimacy with clients, former clients, supervising relatives, sure. Let's explore the topic of dual relationships, multiple relationships, and non-counseling roles in the context of counseling. Understanding these concepts is crucial as you prepare for the CPC exam and your future career in the mental health field. We'll break them down into key concepts, important details, and provide examples to clarify your understanding. 1. Dual relationships and multiple relationships. Dual relationships occur when a counselor has more than one type of relationship with a client. This can include being both a counselor and a friend, family member, or colleague. Multiple relationships often refer to similar situations, but may extend beyond personal relationships to professional connections as well. Key concepts: potential for harm. Dual or multiple relationships can create conflicts of interest or ethical dilemmas, making it difficult for counselors to maintain professional boundaries and provide unbiased support. Professional boundaries. It is essential for counselors to establish and maintain clear boundaries in their relationships to protect both themselves and their clients. 2. Prohibited relationships. Certain types of relationships between counselors and clients are strictly prohibited due to the potential for ethical conflicts. Family relationships. A counselor should not provide services to close family members, as it can create complications in maintaining a professional relationship. Friendships. Counselors are discouraged from treating friends because personal feelings can interfere with the objectivity needed in therapy. Sexual or romantic relationships. Engaging in sexual or romantic relationships with current clients is ethically unacceptable. Relationships with former clients are also typically prohibited for a specified time after termination. 3. Time frames for post-termination relationships. Professional organizations, like the American Counseling Association and the National Board for Certified Counselors, have guidelines about relationships with former clients. ACA. Counselors should avoid entering into a romantic or sexual relationship with a former client for 5 years after terminating the therapeutic relationship. NBCC. Similar rules apply, but with a 2-year prohibition on romantic or sexual relationships post-termination. These timeframes are intended to protect clients from any potential exploitation after therapy ends. 4. Self-referral. Self-referral occurs when counselors refer clients to their own services, which can raise ethical concerns about the counselor's ability to remain objective. Counselors should be cautious and consider whether it is appropriate to refer someone they know personally to their practice. 5. Virtual relationships. With the rise of technology in counseling, virtual relationships can complicate professional boundaries. Counselors should be careful about interacting with clients online, as this can blur the lines between personal and professional relationships. 6. Bartering. Bartering involves exchanging goods or services instead of providing traditional monetary payment for therapy. While this can be culturally accepted in some situations, counselors must ensure that the barter does not exploit the client. It does not create a conflict of interest. Both parties agree on the terms of the barter openly and professionally. For example, a therapist might accept art supplies from an artist client in exchange for therapy sessions. However, they need to ensure it's a fair exchange and doesn't impact their professional relationship. 7. Accepting gifts from clients. Counselors may occasionally receive gifts from clients. While accepting small, thoughtful gifts can be acceptable, larger or more expensive gifts may create a conflict of interest or the appearance of favoritism. Counselors should use discretion and consider the implications of accepting any gifts. 8. Sexual harassment. Counselors have a responsibility to provide a safe space for clients, which includes addressing any claims of sexual harassment. This could involve unwanted sexual advances or inappropriate comments. Counselors must take these claims seriously and act to protect the client's well-being. 9. Sexual intimacy with clients. Former clients. Engaging in sexual intimacy with current clients is unequivocally prohibited due to the power dynamics and potential for exploitation. Many organizations also discourage sexual relationships with former clients for a specified time. 10. Supervising relatives. Counselors should avoid supervision of family members or close friends. This can create conflicts of interest and may affect the objectivity needed in supervision. It is essential to maintain professional boundaries to ensure effective supervision and support. Conclusion. Understanding dual relationships, multiple relationships, and non-counseling roles is crucial for maintaining professional integrity and ethical practice in counseling. Maintaining clear boundaries, being aware of prohibited relationships, and adhering to guidelines regarding post-termination relationships are essential for protecting both counselors and their clients. Mastering these concepts will prepare you well for the CPC exam and your future career in counseling. Professional conduct and competence. Practicing within scope of practice using science and research-grounded theories, informed consent, ethical consultations, discrimination based on sexual orientation or gender identity, referring clients' fee structures, pro bono, reduced fees, hardship adjustments, fee splitting, set office fees, incapacitation, death, retirement planning, continuing education for competence, media presentations, reporting unethical practices of agencies, colleagues' use of outdated assessment data, evaluating counseling clients for legal forensic purposes, case examples, recruiting diverse faculty, students, counselor educators, and fees for placement. Sure. Let's break down the topic of practicing within the scope of practice in counseling. This involves understanding the boundaries of your training and experience, ethical considerations, and best practices for providing effective and responsible counseling. We will cover key concepts, important details, and examples to help clarify this topic for you as you prepare for the CPC exam. 1. Practicing within scope of practice. Scope of practice refers to the boundaries of what a counselor is qualified and permitted to do based on their training, education, and experience. Counselors must practice within these limits to ensure they provide safe and effective care. Key concepts: training and experience. Counselors should only provide services for which they have been adequately trained and experienced. Practicing beyond one scope can lead to harm and ethical issues. Example: if a counselor is trained in school counseling, they should not attempt to provide complex forensic evaluations in a legal setting unless they have specialized training in that area. 2. Using science and research-grounded theories. Counselors should base their practices on scientifically supported theories and research. This ensures that the methods used are effective and appropriate for clients. Important detail: using evidence-based techniques helps counselors provide the best care and improve outcomes for clients. 3. Informed consent. Informed consent is the process of providing clients with clear information about their rights, the nature of the counseling relationship, and any potential risks involved. This typically includes a disclosure statement. Key points: clients should know what to expect from therapy, including confidentiality and any limits to that confidentiality. They must willingly agree to participate in the counseling process. Example: before starting therapy, a counselor gives their client a booklet explaining confidentiality, the therapy process, and potential risks, allowing the client to ask questions. 4. Ethical consultations. Counselors are encouraged to seek ethical consultations when faced with dilemmas or when unsure about how to proceed in complex situations. Consulting with colleagues or supervisors can provide guidance on ethical practices. 5. Discrimination based on sexual orientation or gender identity. Counselors must provide equitable treatment to all clients, regardless of their sexual orientation or gender identity. Discrimination is unethical and can harm clients. Important detail: counselors should strive to create a safe and accepting environment for all clients. 6. Referring clients. Counselors may need to refer clients to other professionals if they lack the knowledge or expertise to address specific issues. This referral should be based on the client's needs and not personal beliefs. Example: if a counselor encounters a client with severe eating disorders and lacks training in that area, they should refer the client to a specialist who can provide appropriate care. 7. Fee structures. Counselors should have transparent fee structures for their services. This can include pro bono, providing services for free for clients in need; reduced fees, offering lower rates based on the client's financial situation; hardship adjustments, adjusting fees based on a client's inability to pay; fee splitting. Counselors should generally avoid this, as it can violate ethical practices; set office fees, clearly stated fees for services. 8. Incapacitation, death, retirement planning. Counselors should have plans in place for incapacity, death, or retirement. This includes ensuring that client records are managed appropriately and clients are taken care of during transitions. Important detail: counselors should inform clients about what will happen to their information and care if they are unable to provide services. 9. Continuing education for competence. To remain effective in their practice, counselors must engage in continuing education. This involves taking courses, attending workshops, or learning about new research to keep their skills sharp. 10. Media presentations. Counselors can use various media to share knowledge and connect with the community. However, they should do so ethically, respecting client confidentiality and avoiding self-promotion. 11. Reporting unethical practices. Counselors have an ethical obligation to report unethical practices of colleagues or agencies. This helps maintain standards within the profession and protects clients from harm. 12. Use of outdated assessment data. Counselors should avoid using outdated assessment data when evaluating clients. Using current and relevant information is crucial for making informed decisions about treatment. 13. Evaluating counseling clients for legal forensic purposes. When counselors provide evaluations for legal or forensic purposes, they must ensure they have the appropriate training and skills to do so ethically. Example: a counselor conducting a psychological evaluation for a court should have training specifically in forensic psychology to provide valid and reliable assessments. 14. Case examples. When discussing client cases for educational or training purposes, counselors must obtain permission from clients or modify details to protect confidentiality. 15. Recruiting diverse faculty. Students. Counselor education programs should aim to recruit diverse faculty and students to reflect various backgrounds and perspectives, fostering a richer learning environment. 16. Counselor educators and fees for placement. Counselor educators might also need to establish fee structures related to student placements, ensuring that students, especially those in training, are appropriately supported during their clinical experiences. Conclusion: practicing within the scope of practice is crucial for ethical counseling. It underscores the importance of using evidence-based methods, obtaining informed consent, and remaining aware of ethical obligations. Understanding these principles will better prepare you for your CPC exam and your future role as a counselor. Technology and distance counseling. Social media policies, separating professional and personal online presence, prohibiting posting client info or seeking client help on forums. Electronic counseling interventions, informed consent for distance counseling, client verification processes for distance counseling, data security. Informing clients about third-party access to electronic files, encryption, public health information, and HIPAA security risks. Skype and HIPAA compliance. Distance counseling laws. Sure. Let's explore the topic of social media policies in counseling. In today's digital world, counselors must navigate various challenges related to their online presence, client confidentiality, and ethical standards. We'll break down key concepts, important details, and provide examples to help you understand this topic as you prepare for the CPC exam. 1. Social media policies. Social media policies refer to rules and guidelines that counselors should follow regarding their online interactions and presence. These are designed to protect both clients and counselors while ensuring ethical practice. Key concepts: friend requests and following clients. Counselors should generally avoid sending friend requests or following clients on personal social media accounts. This helps keep professional boundaries clear and protects client confidentiality. Privacy concerns. Counselors must be aware of privacy settings on social media platforms and keep their personal accounts private to minimize the risk of accidental contact with clients. 2. Separating professional and personal online presence. Counselors should maintain a clear separation between their professional and personal online lives. Professional accounts. Counselors might create dedicated professional pages or account for their practice. This allows them to share helpful resources without blending their personal lives with their professional roles. Personal accounts. Counselors should keep their personal social media accounts private and separate to protect their own privacy and avoid potential conflicts with clients. 3. Prohibiting posting client information. Counselors must not post any information about clients on social media or online forums, including seeking advice or support regarding client cases. This ensures client confidentiality and protects their privacy. Example: a counselor should not say, "I had a terrible session with a client today" on social media, as this could lead to identifying the client, even if names are not mentioned. 4. Electronic counseling interventions for clients who are chronically suicidal or at high risk. Counselors must carefully consider the suitability of electronic counseling interventions. It's essential to assess whether the technology can adequately support the client's needs. Important detail: counselors should ensure they have crisis intervention strategies in place for clients who may be in crisis during remote sessions. 5. Informed consent for distance counseling. Informed consent is crucial for distance counseling. This involves explaining to clients the specifics of the counseling process conducted online. Key points: technology failure. Clients should be informed that technical issues could interrupt sessions. Response time. Counselors should let clients know how quickly they can expect responses to messages or texts. Risks. Counselors must discuss potential risks associated with online counseling, such as privacy concerns and limits to confidentiality. 6. Client verification processes for distance counseling to ensure the safety and appropriateness of counseling services. Counselors should implement client verification processes. This could involve confirming the identity of clients before beginning sessions to prevent unauthorized access to counseling services. 7. Data security counselors need to prioritize data security to protect client information, especially when using electronic methods, cloud storage, and backups. Counselors should use secure cloud storage solutions with backups to protect sensitive data and ensure it is retrievable in case of data loss. Third-party access. Counselors should inform clients if there are third parties that might have access to their electronic files and under what circumstances this could happen. 8. Encryption. Encryption is the process of protecting information by converting it into a code. This is vital for counselors when handling sensitive information. Website contact forms. Counselors should use secure, encrypted contact forms on their websites to protect clients' personal health information when clients reach out. PHI and HIPAA compliance. Under the Health Insurance Portability and Accountability Act, counselors must ensure that any electronic communications containing PHI are encrypted to protect clients' confidentiality. 9. Public health information and HIPAA counselors must comply with HIPAA regulations regarding the confidentiality of public health information. They should always ensure that client data is kept private and secure, especially when utilizing electronic communication. 10. Security risk counselors should be aware of security risks associated with managing their online presence. Passwords. Strong passwords should be used to protect accounts. It's essential not to share passwords and to change them regularly to enhance security. Public Wi-Fi. Using public Wi-Fi networks can pose risks for accessing client records. Counselors should avoid using public networks for counseling-related work or use a virtual private network for added security. 11. Skype and HIPAA compliance. If counselors use platforms like Skype for video counseling, they must ensure that these tools comply with HIPAA regulations for confidentiality and security. Using HIPAA-compliant platforms for telehealth services protects client information during online sessions. 12. Distance counseling laws. Counselors must be aware of the legal regulations regarding distance counseling, especially if the laws in their practicing state differ from those in the client state. This is important to ensure compliance with regulations governing the delivery of counseling services across state lines. Conclusion. Understanding social media policies and the implications of distance counseling is crucial for maintaining ethical practice as a counselor. By following these principles, counselors can protect client confidentiality, set appropriate boundaries, and provide competent and secure counseling services in both traditional and digital contexts. Mastering these concepts will help you succeed in the CPC exam and your future career in counseling. Specific therapies and interventions. Conversion reparative therapies, paradoxical interventions. Let's break down the topic of conversion therapies and paradoxical interventions, including what they are, why they're prohibited, and their implications in counseling. This topic is important for understanding ethical practices in counseling and preparing for your CPC exam. 1. Conversion reparative therapies. Conversion therapy, also known as reparative therapy, refers to practices aimed at changing a person's sexual orientation or gender identity from LGBTQ+ to heterosexual or cisgender. Key concepts: prohibition. Many mental health organizations and professional associations, such as the American Psychological Association and the American Counseling Association, condemn conversion therapy due to its potential to cause significant psychological harm. As a result, many jurisdictions have banned these practices. Ineffectiveness. Research has consistently shown that conversion therapy is ineffective and does not change sexual orientation. It can cause confusion, depression, anxiety, and low self-esteem among individuals who undergo these therapies. Important details: ethical concerns. Conversion therapy violates ethical guidelines within counseling because it promotes a harmful agenda against individuals' identity, which is contrary to the principles of respect and dignity in therapy. Example: a counselor who tells a client that they need to change their sexual orientation to fit societal norms and uses harmful methods falls into the realm of conversion therapy. This practice is unethical and has been widely discredited. 2. Paradoxical interventions. Paradoxical interventions are therapeutic techniques where a counselor prescribes the very problem the client wants to change. While this may sound counterintuitive, it can help clients confront their behaviors and create change in a unique way. Key concepts: usefulness. These interventions can be effective for some clients in certain situations, nudging them to recognize their behaviors and the resistant attitudes they may have toward change. Contraindicated for at-risk clients. Paradoxical interventions are not suitable for clients who are suicidal or homicidal. In such cases, these clients may misinterpret the message or feel further distressed or pushed into risky behaviors. Important details, caution required. Therapists must be careful when using paradoxical strategies, as they can lead to misunderstandings or exacerbate a client's issues if they are not ready for such techniques. Example: imagine a client who struggles with procrastination and feels pressure to complete tasks. A counselor might suggest that the client intentionally procrastinate even more. The idea is that by doing so, the client could develop a new awareness of their behavior and ultimately motivate themselves to act. However, if this client is also struggling with suicidal thoughts, this technique could be dangerous and negatively affect their mental state. Conclusion: understanding conversion therapies and paradoxical interventions is critical in the counseling field. Conversion therapy is widely condemned and prohibited due to its harmful impacts on individuals. On the other hand, while paradoxical interventions can be a useful tool, they require careful consideration and should not be used with clients at risk of suicide or harm. Knowing these concepts will help you practice ethically and effectively in your future counseling career and prepare you well for the CPC exam. Legal aspects. Legal liability versus ethical violations, certainly. Let's break down the concepts of legal liability and ethical violations in the context of counseling and mental health practice. Understanding these differences is crucial as you prepare for the CPC exam. We will clarify each term, explain key concepts, and provide examples for better understanding. 1. Legal liability. Legal liability refers to the legal responsibility a counselor holds if they cause harm to a client or fail to meet established professional standards. If a counselor is found legally liable, they may face lawsuits, fines, or other legal consequences. Key concepts: negligence. This is a common basis for legal liability and occurs when a counselor fails to provide the standard of care that a reasonable counselor would provide. This means that if a counselor doesn't follow established guidelines or protocols, they may be held liable for the consequences. Duty of care. Counselors have a duty to provide care and protect the well-being of their clients. If they breach this duty, they may be legally liable. Important details. Counselors can face legal liability for various reasons, including failing to report child abuse or neglect, failing to prevent a client from harming themselves or others, breaching confidentiality without justification. Example: if a counselor sees a client who expresses thoughts of self-harm but does not take proper action to ensure the client's safety, and the client later harms themselves, the counselor could be held legally liable for negligence. 2. Ethical violations. Ethical violations occur when a counselor breaks the ethical code or professional standards set by their profession. These codes are established by organizations like the American Counseling Association or the American Psychological Association to promote ethical behavior and protect clients. Key concepts: professional guidelines. Counselors must adhere to ethical guidelines that dictate how they should behave professionally. These guidelines include respecting client confidentiality, avoiding conflicts of interest, and obtaining informed consent. Confidentiality. Maintaining the privacy of client information is a fundamental ethical obligation for counselors. Sharing this information without permission can be considered an ethical violation. Important details: ethical violations may not always lead to legal consequences, but they can damage a counselor's reputation and professional standing. Counselors may face disciplinary action from licensing boards or professional organizations for ethical violations, including loss of licensure or certification. Example: if a counselor forms a romantic relationship with a current client, this would violate ethical guidelines, even if it did not result in any legal harm. The counselor could face disciplinary actions from their licensing board. Differences between legal liability and ethical violations summary. Understanding the differences between legal liability and ethical violations is crucial for counselors. Legal liability involves legal consequences for causing harm or neglecting duties, while ethical violations involve breaching professional standards and codes of conduct. Both can have significant implications for a counselor's career, but they operate in different realms, one legally and the other ethically. Being aware of these concepts will help you maintain high standards in your counseling practice and prepare for your CPC exam. Sure, Let's explore the topic of court orders and subpoenas in the context of counseling and how they relate to confidentiality and legal obligations. Understanding these concepts is important as you prepare for the CPC exam. We'll break down the key concepts, important details, and provide examples to clarify your understanding. 1. Court orders. A court order is an official directive issued by a judge that requires individuals or organizations to do or refrain from doing certain actions. In the context of counseling, court orders can impact how counselors handle client information. Key concepts: legal authority. A court order has the legal authority behind it. This means that if a counselor receives a court order, they're legally required to comply, even if it means breaching client confidentiality. Types of court orders. There are various types of court orders, including custody orders, determining where children will live after a divorce. Protection orders, providing safety measures for individuals who might be threatened or harmed. Important details. Counselors may be compelled to release confidential information or provide testimony if a court order requires it. It's important for counselors to carefully review the court order and seek legal advice if necessary to understand their obligations. Example: if a counselor is treating a client involved in a custody dispute and receives a court order requesting all therapy notes related to that client, the counselor must comply and provide the requested documents, even though this may breach confidentiality. 2. Subpoenas. A subpoena is a type of legal document that orders a person to appear in court or produce specific documents or evidence. Subpoenas can be issued in both civil and criminal cases. Key concepts. 2 main types of subpoenas. Subpoena ad testificandum. This type requires a person to testify in court. Subpoena dut ses tecum. This type requires a person to produce documents, records, or evidence for a court case. Legal obligation. Like court orders, receiving a subpoena means that the counselor is legally obligated to respond to it, generally within a specified time frame. Important details. Counselors should be cautious when responding to subpoenas, particularly concerning client confidentiality. They should only disclose the information that is specifically requested in the subpoena. Counselors can adjust their response if they believe the subpoena is overly broad or infringes on client confidentiality. They can consult with legal counsel or seek to quash the subpoena. Example: if a counselor receives a subpoena requiring them to bring all records related to one of their clients to a court hearing, they need to prepare those documents. However, if the documents contain sensitive information beyond what the court needs, the counselor may work with a lawyer to protect the client's confidentiality while complying with the subpoena. Key points to remember: confidentiality versus legal obligations. Counselors must maintain client confidentiality, but legal documents like court orders and subpoenas can override this duty. Counselors should be aware of their legal responsibilities when dealing with these documents. Seek guidance. When unsure about how to respond to a court order or subpoena, counselors should seek guidance from legal counsel to protect both their clients and themselves. Documentation. Counselors should keep detailed records of any court orders and subpoenas received and document how they responded to them. Conclusion: understanding court orders and subpoenas is essential for counselors. These legal documents can significantly impact how counselors manage client confidentiality and legal responsibilities. By knowing how to handle these situations, counselors can navigate the complexities of legal obligations while still striving to protect their clients' rights. This knowledge will help you prepare for your CPC exam and your future career in counseling. Sure, let's break down the concepts of malpractice and liability insurance as they relate to counseling and mental health practice. Understanding these terms is important as you prepare for the CPC exam. We'll clarify key concepts, important details, and provide examples to help you grasp the topic. 1. Malpractice. Malpractice occurs when a professional fails to perform their duties to the standard expected in their field, resulting in harm or injury to a client. In counseling, this can refer to situations where a counselor does not provide adequate care or makes significant errors that negatively affect the client. Key concepts: negligence. Malpractice usually falls under the category of negligence. This means that the counselor did not act as a reasonably competent professional would in similar circumstances. Standards of care. Counselors must follow established standards of care, which are guidelines and practices set by professional organizations. If a counselor falls below these standards, they may be considered liable for malpractice. Important details. Examples of malpractice in counseling: failing to report suspected child abuse when required by law, not taking the appropriate steps to protect a client who expresses suicidal thoughts, providing treatment outside of one's area of expertise without proper qualifications. Example: imagine a counselor who is treating a client with severe depression. The client talks about feeling suicidal, but the counselor doesn't take necessary precautions to ensure the client's safety or refer them to a higher level of care. If the client subsequently harms themselves, the counselor could be sued for malpractice because they did not meet the expected standard of care to protect the client's safety. 2. Liability insurance. Liability insurance is a type of insurance that protects professionals against claims of malpractice or negligence. This insurance helps cover the costs associated with legal defense, settlements, or judgments if a lawsuit is filed against them. Key concepts: financial protection. Liability insurance provides financial protection for counselors, which can help cover legal fees and any compensation awarded to clients if a claim of malpractice is proven. Types of coverage. There are different types of liability insurance available. Professional liability insurance. This covers counselors for malpractice claims related to their professional services. General liability insurance. This covers claims arising from accidents or injuries that occur on a counselor's premises. Important details: required or recommended. While liability insurance may not be legally required for counselors in every state, it is highly recommended. Having insurance can protect counselors' financial stability and professional reputation in case of a lawsuit. Cost. The cost of liability insurance can vary based on factors like the counselor's experience, specialization, and claims history. Example: suppose a counselor is sued for malpractice after a client claims that their treatment caused harm. Without liability insurance, the counselor would be responsible for paying all legal fees and settlements out of their pocket, which could be financially devastating. However, with liability insurance, the insurance company would handle much of the financial burden, covering legal costs and potential compensation. Key points to remember: malpractice involves the failure of a counselor to adhere to professional standards, leading to harm to a client. Liability insurance protects counselors for financial loss due to claims of malpractice, making it an essential safety net for those in the counseling profession. Counselors should understand their legal responsibilities and consider obtaining liability insurance to safeguard their practice and financial well-being. Conclusion: understanding malpractice and liability insurance is crucial for anyone entering the counseling profession. Being aware of the risks of malpractice and the protections offered by liability insurance can help counselors practice ethically and responsibly, ultimately contributing to better outcomes for their clients. This knowledge will be beneficial as you prepare for the CPC exam and embark on your career in counseling. Let's break down the topic of defamation, focusing on its two main forms: libel and slander. Understanding these terms is important for anyone working in counseling, as they can have serious implications for professional practice. We'll explain the key concepts, provide important details, and give examples to clarify your understanding. What is defamation? Defamation is a legal term that refers to any false statement that harms someone's reputation. If someone makes a statement that damages another person's reputation, the harmed person may be able to sue for defamation. There are two main types of defamation. 1. Libel. 2. Slander. 1. Libel is defamation that occurs in written or published form. This means the false statement is recorded in some way, such as in books, articles, online posts, or social media. Key concepts: written statements. Libel involves any false statements that are written and can be seen by others. Harm to reputation. The statement must be harmful and must negatively affect the person's reputation. Important details: examples of libel. If a newspaper publishes an article that wrongfully states a counselor engaged in unethical behavior, and that statement is false, the counselor could sue for libel, as it damages their reputation through written words. Example: if a counselor writes a blog post that falsely claims a colleague is a fraud and does not actually have the qualifications they claim, that post could be considered libel. The colleague could sue for defamation due to the written nature of the statement. 2. Slander. Slander is defamation that occurs in spoken form. This means the false statement is made verbally and heard by others, but is not recorded in writing. Key concepts: spoken statements. Slander involves verbal claims that can harm someone's reputation. Transitory nature. Unlike libel, which is permanent in written form, slander is more transient because it's spoken and may not be recorded. Important details: examples of slander. If someone tells others at a gathering that a counselor has been arrested for theft when that is not true, and this affects the counselor's reputation, this could be classified as slander. Example: if a client tells friends during a conversation that their counselor is incompetent and has harmed them, without any basis in truth, This could be slander. The counselor could potentially sue the client for defamation if the statement causes significant harm to their professional reputation. Key points to remember: defamation includes both libel and slander, which involve false statements harming someone's reputation. Libel, written or published defamation. Slander, spoken defamation. For a defamation claim to be successful, the statement must be proven false, damaging, and made with the intent to harm or with negligence about its truthfulness. Conclusion: understanding defamation, including its types, is crucial for counseling professionals. Counselors must be cautious about how they speak about others and what they put in writing, as false statements can lead to serious legal consequences. This knowledge is important as you prepare for the CPC exam and embark on your career in counseling, so you can protect yourself and your professional reputation. State laws governing title usage and practice. Let's break down the topic of state laws governing title usage and practice in the context of counseling and mental health professions. This is an important subject for anyone studying for the CPC exam, as it affects how professionals can represent themselves and their qualifications. We will explain key concepts, provide important details, and give examples to clarify your understanding. What are state laws governing title usage and practice? State laws regarding title usage and practice refer to the regulations and standards set by individual states about how mental health professionals can use specific titles and how they must practice in their professions. These laws help to protect clients by ensuring that only qualified individuals provide specific services. Key concepts: 1. Licensing requirements. Each state has its own licensing requirements for various mental health professions, such as counseling, psychology, psychotherapy, and social work. To practice legally and use a particular title, professionals must meet the educational, training, and examination requirements set by the state. 2. Protected titles. Certain titles, such as licensed professional counselor, licensed clinical social worker, or psychologist, are protected by law. This means that only individuals who meet specific criteria and obtain a license can use these titles. Using these titles without the proper licensure is illegal and could result in penalties. 3. Scope of practice. Each state defines what a professional can and cannot do within their field, known as their scope of practice. This helps to ensure that practitioners do not engage in activities for which they are not qualified. For example, a counselor may be trained to provide therapy, but may not be authorized to prescribe medication unless they hold specific credentials allowing them to do so. 4. Continuing education. Most states require licensed professionals to complete continuing education courses to maintain their licenses. This ensures that they stay updated on the latest practices, ethics, and research in their fields. Important details: state variations. Laws, requirements, and protected titles can vary significantly from one state to another. It's crucial for counselors and other professionals to be aware of the specific regulations in their state. Examples of common titles. Licensed professional counselor requires a master's degree in counseling, supervised experience, and passing a licensing exam. Psychologist typically requires a doctoral degree in psychology, supervised experience, and passing state exams. Example of state laws in action. Imagine a person in Texas who has completed a master's degree in counseling and wants to become a licensed professional counselor. To obtain their license, they would need to: 1. Complete the required supervised clinical experience. 2. Pass the National Counselor Examination. 3. Submit their application, along with any required fees, to the Texas State Board of Examiners of Professional Counselors. If they do not meet these requirements or practice without a license, they could face legal consequences, including fines or being barred from practicing. Consequences of violating state laws: 1. Legal penalties. Practicing without a proper license could lead to fines, suspension, or revocation of professional credentials. 2. Civil liability. If clients are harmed due to unlicensed practice, the unlicensed professional could be held liable in a civil court. 3. Professional reputation. Violating state laws can lead to damage to a professional's reputation, diminishing their credibility and ability to practice. Conclusion: understanding state laws governing title usage and practice is essential for anyone entering the counseling profession. Being aware of licensing requirements, protected titles, and scope of practice helps protect clients and ensures that professionals provide effective and ethical care. This knowledge will be beneficial as you prepare for the CPC exam and your future career in counseling. Involuntary commitment. Let's break down the topic of involuntary commitment in a way that is easy to understand. This is an important concept in mental health and counseling, and it's crucial to know about it as you prepare for the CPC exam. What is involuntary commitment? Involuntary commitment is a legal process through which a person with a severe mental health condition is admitted to a psychiatric hospital or mental health facility against their will. This usually happens when a person poses a danger to themselves or others or is unable to care for themselves due to their mental illness. Key concepts 1. Criteria for involuntary commitment. For someone to be involuntarily committed, they typically must meet certain criteria, which may vary by state. Common criteria include danger to self. If a person is at risk of harming themselves, such as having suicidal thoughts or attempting suicide. Danger to others. If a person poses a threat to others, for instance, if they express intentions to harm someone else. Inability to care for oneself. If a person cannot take care of their basic needs, such as food, shelter, and hygiene, due to their mental health condition. 2. Process of involuntary commitment. Initial assessment. Typically, a mental health professional evaluates the individual to determine whether involuntary commitment is needed. Emergency hold. In many cases, an individual may be placed on an emergency hold for a short period while they undergo evaluation. Court hearing. If the professional believes involuntary commitment is necessary, a court hearing may be held. At this hearing, evidence is presented to a judge who will decide whether the commitment is justified. 3. Legal rights. Individuals who are involuntarily committed have legal rights, such as the right to legal representation during the commitment process. Participate in hearings regarding their treatment and release. Important details. Duration of commitment. The length of time someone can be involuntarily committed may vary by state law and the severity of the condition. Some states may allow commitment for a few days or weeks, while others may have longer time frames. Treatment and release. While committed, individuals typically receive treatment for their mental health conditions. Once they no longer meet the criteria for commitment, they can be discharged. Examples 1. Suicidal thoughts. A young adult tells a friend that they are planning to harm themselves. Concerned, the friend contacts a mental health professional. After evaluation, the professional determines that the individual poses a significant risk of self-harm. The young adult is then involuntarily committed to a treatment facility for their safety. 2. Threatening behavior. A man with untreated schizophrenia begins making threats towards his neighbor, expressing violent thoughts. Police are called, and upon evaluation by a mental health professional, they decide he should be involuntarily committed to ensure his safety and the safety of others. Conclusion. Understanding involuntary commitment is important in the field of mental health. It is a legal process used to provide help and safety for individuals facing severe mental health issues who cannot make safe decisions for themselves. Knowing the criteria, process, and legal rights involved in involuntary commitment is essential as you prepare for the CPC exam and your future career in counseling. This knowledge can help you advocate for the best care for individuals in crisis while respecting their rights. Family Educational Rights and Privacy Act. Let's break down the Family Educational Rights and Privacy Act in a simple and clear way. This law is important for understanding how educational records are handled, especially in the context of counseling within schools. Knowing about FERPA is essential as you prepare for the CPC exam. What is FERPA? The Family Educational Rights and Privacy Act is a federal law enacted in 1974 that protects the privacy of student education records. It gives parents certain rights regarding their children's educational records and sets rules on how those records can be accessed and shared. Key concepts 1. Who is covered by FERPA? FERPA applies to all schools that receive federal funding. This includes public schools, colleges, and universities. The rights granted under FERPA transfer from parents to students when the student turns 18 or attends a school beyond the high school level. This is known as the age of majority. 2. Rights provided by FERPA. Right to access records. Parents and eligible students have a right to inspect and review the student's education records maintained by the school. Right to request corrections. If a parent or eligible student believes that information in the education record is inaccurate or misleading, they have the right to request changes. Right to consent to disclosures. Schools must get written consent from parents or eligible students before releasing personally identifiable information from a student's education records, except in certain situations. 3. What are education records? Education records refer to any records that are directly related to a student and maintained by an educational institution. This includes academic records, disciplinary records, Health records maintained by the school. Counseling records. 4. Exceptions to consent. There are specific situations where schools can disclose information without consent to school officials with a legitimate educational interest, to comply with a judicial order or subpoena. In cases of health and safety emergencies. Important details directory information. FERPA allows schools to disclose certain limited information, known as directory information, without parental consent. This can include a student's name, address, phone number, and email, but students or parents can request that this information be kept confidential. Privacy and record maintenance. Schools must maintain the privacy of education records and implement measures to protect sensitive information. Examples 1. Accessing records. A parent wants to see their child's academic records and disciplinary history. Under FERPA, they can request to view these records from the school, and the school must allow them to see the information within a reasonable time. 2. Correcting records. If a student finds an error in their transcript, such as a grade that was recorded incorrectly, the student can request that the school correct this mistake. 3. Releasing information. A school counselor wishes to share a student's information with a college the student is applying to. The counselor must first obtain written consent from the student or parent before doing so, unless it's for an exception under FERPA. Conclusion: understanding the Family Educational Rights and Privacy Act is crucial for professionals in the educational and counseling fields. It protects students' rights regarding their educational records and establishes guidelines for how information can be shared. Knowing FERPA helps ensure that students' privacy is respected and that their records are handled appropriately as you prepare for your CPC exam and your future career in counseling or education. Education for All Handicapped Children Act. Let's explore the Education for All Handicapped Children Act. This law is significant in the history of special education in the United States and plays an important role in ensuring that children with disabilities receive suitable educational opportunities. As you prepare for the CPC exam, understanding this law is essential. What is the Education for All Handicapped Children Act? The Education for All Handicapped Children Act was enacted in 1975 to ensure that children with disabilities have the right to a free and appropriate public education. This law was a groundbreaking step toward providing equal educational opportunities for children with various disabilities and has since evolved into what is now known as the Individuals with Disabilities Education Act. Key concepts: 1. Free appropriate public education. The law mandates that all children with disabilities be provided with an education at no cost to their families that is appropriate to their individual needs. This means schools must create educational programs tailored to each child's unique requirements. 2. Individualized Education Program. An important requirement of PL 94 to 142 is the development of an individualized education program for each child with a disability. The IEP is a written document that outlines the child's educational goals, the services they will receive, and how their progress will be measured. Parents, teachers, and other professionals work together to create the IEP, ensuring it reflects the child's needs. 3. Least restrictive environment. The law emphasizes that children with disabilities should be educated alongside their non-disabled peers to the maximum extent appropriate. This is known as the least restrictive environment. Schools must provide services and supports that enable children to participate in general education classrooms whenever possible. 4. Parent and student involvement. PL 94 to 142 requires schools to involve parents in the decision-making process regarding their child's education. Parents have the right to be informed about their child's progress and to participate in the creation of the IEP. 5. Protection of rights. The law established rights for students with disabilities and their families, including the right to challenge decisions made by the school if they feel the child's needs are not being met. Important details: eligibility. PL 94 to 142 applies to children aged 3 to 21 who have specific disabilities, including but not limited to learning disabilities, autism, mental retardation, emotional disturbances, and sensory impairments. Development over time. The original law has been amended several times and is now known as IDEA, allowing for broader protections and rights for students with disabilities. Funding. The law provides federal funding to states to assist with the educational needs of children with disabilities, helping schools implement the services required by the law. Examples: 1. Creating an IEP. A child with autism is struggling in a regular classroom. The school holds a meeting with the child's parents, special education teacher, and regular education teacher to develop an IEP. This IEP might include goals for social skills, additional support in the classroom, and specific teaching strategies to help the child succeed. 2. Least restrictive environment. A student with a learning disability may spend most of their day in a general education classroom with support from a special education teacher instead of being placed in a separate classroom. This allows the student to learn alongside peers and interact socially while receiving the help they need. 3. Parent rights. If a parent feels their child is not receiving the services outlined in the IEP, they can request a meeting to discuss their concerns, or they may seek mediation or file a complaint with the school district. This ensures that the student's rights are protected under the law. Conclusion: the Education for All Handicapped Children Act laid the foundation for ensuring that students with disabilities receive a free, appropriate public education, individual support through IEPs, and the right to inclusion in general education classrooms. Understanding this law is essential for future counselors, educators, and mental health professionals, as it highlights the importance of equal educational opportunities and the rights of children with disabilities. This knowledge will be helpful for you as you prepare for the CPC exam and your future career. Americans with Disabilities Act. Let's break down the Americans with Disabilities Act in a simple and clear way. This important law helps to ensure equal rights and opportunities for individuals with disabilities in various areas of life, including employment, public services, transportation, and more. Understanding the ADA is crucial as you prepare for the CPC exam. What is the Americans with Disabilities Act? The Americans with Disabilities Act was signed into law in 1990. It's a civil rights law in the United States that prohibits discrimination against people with disabilities and ensures that they have the same rights and opportunities as everyone else. Key concepts. 1. Definition of disability. Under the ADA, a disability is defined as a physical or mental impairment that significantly limits one or more major life activities. It can also include a history of such an impairment or being perceived as having one. 2. Major areas covered by the ADA. Employment. Employers with 15 or more employees cannot discriminate against qualified individuals with disabilities in hiring, firing, promotions, or any other employment practices. Employers are also required to provide reasonable accommodations to help employees perform their jobs. Public services. State and local government agencies must make their services, programs, and activities accessible to individuals with disabilities. This includes public transportation and access to government buildings. Public accommodations. Businesses and nonprofit organizations that serve the public must ensure that their facilities are accessible. This includes restaurants, hotels, theaters, and stores. They must remove barriers to access, provide accessible restrooms, and offer auxiliary aids when necessary. Telecommunications. This section requires telephone and internet companies to offer services that are accessible to individuals with hearing and speech impairments. 3. Reasonable accommodations. Employers and public services must make adjustments or reasonable accommodations to help individuals with disabilities participate fully. For example, this can include providing sign language interpreters, modifying work schedules, or making physical changes to a building to allow wheelchair access. 4. Enforcement. Individuals who believe they have been discriminated against because of their disability can file complaints with the government or take legal action. The ADA is enforced by various federal agencies, including the Equal Employment Opportunity Commission for Employment Issues and the Department of Justice for Public Accommodations. Important details. Coverage. The ADA covers a wide range of disabilities, including physical disabilities, sensory impairments, and mental health conditions. Significant updates. The law was amended in 2008 to expand the definition of disability and make it easier for individuals to be protected under the Act. This means more people can claim protections under the ADA. Examples. 1. Employment example. A qualified job applicant with a visual impairment applies for a job. The employer is required to provide a screen reader software as a reasonable accommodation to help the applicant perform their job tasks, as long as it doesn't cause undue hardship to the employer. 2. Public accommodation example. A restaurant must ensure that its entrances are wheelchair accessible and provide menus in Braille if it serves visually impaired customers. If the restaurant gets a complaint that it is not wheelchair accessible, it must make the necessary changes to comply with the ADA. 3. Public services example. A city must provide accessible public transportation for individuals with disabilities, including buses with ramps and audio announcements for passengers who are vision impaired. Conclusion: the Americans with Disabilities Act is a vital law that aims to protect the rights of individuals with disabilities and promote their full participation in society. By prohibiting discrimination and requiring accommodations, the ADEA helps create equal opportunities for everyone. Understanding the ADEA is essential for anyone entering the counseling and mental health fields because it ensures that individuals with disabilities receive the support and access they need. This knowledge will be helpful as you prepare for the CPC exam and your future career. Legal versus ethical standards. Let's break down the topic of legal versus ethical standards to help you understand the differences and how they apply, especially in the context of counseling and mental health. This knowledge is important as you prepare for the CPC exam. What are legal standards? Legal standards are rules and regulations set by laws enacted by local, state, and federal governments. They dictate what is permissible and what is not in a society, and violating these laws can result in legal consequences such as fines, imprisonment, or loss of professional licenses. Key concepts. Based on laws, legal standards are established by statutes and regulations. They are written and documented, so everyone knows what is required or prohibited. Enforced by the government. Legal standards must be followed, and if they are violated, legal action can be taken against the person or organization that broke the law. Important details. Legal standards often cover a wide range of issues, including professional conduct, licensing requirements for counselors and therapists, confidentiality laws, laws about protecting client information, reporting requirements, laws requiring professionals to report child abuse, elder abuse, or threats of harm. Example of legal standards. If a counselor is aware that a client is abusing a child, the law may require the counselor to report this information to authorities. Failing to do so could result in legal consequences for the counselor. What are ethical standards? Ethical standards are guidelines set by professional organizations, like the American Counseling Association or the American Psychological Association. They represent the moral principles that guide how professionals should conduct themselves in their work. Key concepts. Based on principles. Ethical standards are based on values such as respect, integrity, responsibility, and fairness. They may not always be written into law, but are essential for maintaining professionalism and trust. Not legally binding. While ethical standards are important, they're not enforced by the government. However, violating ethical standards can lead to consequences such as loss of professional credentials, disciplinary action from professional organizations, or damage to one's reputation. Important details. Ethical standards often include confidentiality, maintaining the privacy of client information, competence, only providing services within one's area of training and expertise, informed consent, ensuring clients understand the services provided and agree to them. Example of ethical standards. If a counselor has a dual relationship with a client, it may not be illegal, but it could be considered unethical. This is because such a relationship might impair the counselor's objectivity and effectiveness. Key differences between legal and ethical standards. Conclusion: understanding the difference between legal and ethical standards is crucial for anyone entering the counseling profession. Legal standards provide a framework of rules that must be followed to avoid legal repercussions, while ethical standards ensure that professionals act with integrity and uphold the values of their profession. By distinguishing between these two types of standards, you can better navigate the complexities of counseling and improve your practice as you prepare for the CPC exam. Historical context of counseling. Pioneers, certainly. Let's explore the contributions of Jay Haley, who is considered a pioneer in the field of counseling and psychotherapy. Understanding his work will give you insights into the evolution of therapeutic practices, which is important for your CPC exam preparation. Who is Jay Haley? Jay Haley was an influential American psychologist and psychotherapist known for his work in the field of family therapy and strategic therapy. He made significant contributions to understanding how people interact and communicate within relationships, especially in families. Key concepts. 1. Strategic family therapy. Haley is best known for developing strategic family therapy, which focuses on problem solving and changing behaviors within family dynamics. The idea is to address and resolve specific issues by changing the way family members interact with and relate to each other. In contrast to traditional therapy, which often explores past experiences and emotions, strategic therapy emphasizes action and direct interventions to bring about change. 2. Communication patterns. Haley believed that many problems arise from dysfunctional communication patterns within families. By identifying and altering these patterns, therapists can help families improve their interactions. He emphasized the importance of understanding the messages that family members communicate verbally and non-verbally. 3. Therapeutic techniques. Interventions. Haley introduced specific therapeutic techniques to help families shift their dynamics. For example, he might ask family members to engage in certain behaviors during therapy to observe and alter their interactions. Reframing. This technique involves changing the way a situation is interpreted. By helping clients see a problem from a different perspective, therapists can open new pathways for communication and solutions. 4. Focus on solutions. Haley's approach is often described as solution-focused, meaning that it aims to identify and implement solutions to specific problems rather than focusing solely on understanding the problem itself. This approach encourages clients to think about what they want to achieve rather than dwelling on what is wrong. Important details influence on family therapy. Jay Haley was instrumental in shifting the field of therapy from individual-focused treatment to include the entire family system. His work has influenced many therapists and prompted further research and development in family therapy approaches. Writings. Haley authored several important books that discuss his theories and techniques, including Problem-Solving Therapy and The Interactional View. These texts remain significant resources for students and practitioners in the field. Example of Haley's approach in therapy: imagine a family where the parents argue frequently and the children are becoming increasingly withdrawn. A therapist using Haley's strategic approach might: 1. Identify the communication patterns. Observe how family members interact during sessions to identify harmful patterns. 2. Implement interventions. Suggest that during the next session, the parents practice a calm way of discussing their disagreements without raising their voices. They might be asked to agree on a signal to use when discussions become too heated, reminding them to pause and cool down. 3. Reframe the situation. Help the parents see their arguments not just as failure points, but as opportunities to discuss their differing values. This change in perspective can lead to constructive conversations rather than conflict. Conclusion: Jay Haley's contributions to psychology and therapy shaped how therapists approach family dynamics and problem solving. His emphasis on strategic interventions and the importance of communication within families has had a lasting impact on the field. By studying his methods and ideas, you can gain valuable insights into family therapy and enhance your understanding of different therapeutic approaches as you prepare for the CPC exam. First, ethics codes. Let's break down the topic of first ethics codes, focusing on the codes developed by the American Psychological Association and the National Association of Social Workers. Understanding these ethics codes is important for anyone preparing for a career in psychology or social work, especially as you study for the CPC exam. What are ethics codes? Ethics codes are sets of guidelines designed to help professionals conduct their work with integrity and in a manner that is respectful of clients, colleagues, and society as a whole. They outline the values and principles that guide professional behavior and decision-making. Key concepts of ethics codes. 1. Purpose of ethics codes. The main goal of ethics codes is to ensure that professionals act in a responsible manner, prioritize client welfare, and uphold the integrity of their profession. These codes help establish trust between professionals and their clients. 2. Core ethical principles. Both the APA and NASW ethics codes include core principles such as confidentiality, respecting the privacy of client information and only sharing it when necessary, such as when there is a risk of harm. Informed consent, ensuring clients understand the nature of their treatment or services, including any risks involved, and obtaining their consent before proceeding. Competence. Professionals must provide services within their areas of expertise and seek additional education or training as needed. American Psychological Association Ethics Code 1. History. The APA was established in 1892, and it created its first formal ethics code in 1953. This code has undergone several revisions to adapt to changing social norms and advancements in psychology. 2. Key areas. The APA Ethics Code emphasizes the following areas: beneficence and non-maleficence. Psychologists should strive to help their clients and avoid causing harm. Fidelity and responsibility. Psychologists should establish relationships of trust and uphold their professional responsibilities. Justice. Fair treatment and options must be available to all clients, regardless of their background or identity. 3. Enforcement. Violations of the APA Ethics Code can lead to disciplinary actions, including suspension or expulsion from the association or loss of professional licensure. National Association of Social Workers Code of Ethics.